Hi everybody for our housing series. This one is a good one. It's Christelle Azzi from Community Legal Services of Ottawa who's going to talk to us about the rights of renters.
Hello, everybody. My name is Stéphanie Plante, Councillor for Ward 12. As you know, we've been doing this video series to try to navigate people through our housing crisis, which has definitely hit the downtown area very hard. And we're hoping to give you some answers today to some of the questions you've been sending me. Again, not an expert, so I brought an expert because that's the only way to get through these trying times. And I also have as well in the Zoom Sarah Ann. You guys may have known her if you called my office. But we're going to cede the floor right now to Christelle Azzi. Christelle, can you just tell us a bit about yourself before we get this session started?
Yes, thank you very much for having me here. So I'm a staff lawyer at Community Legal Services of Ottawa, one of the three offices of Community Legal Services. I did both my undergraduate degree and my Juris Doctor degree at the Faculty of Law at the University of Ottawa. I've worked in the clinic system for a really long time as a student, and so I knew when I graduated I was going to come right back to this area of law. I practiced both in housing law and in social assistance law.
And I do apologize. There's like a cell phone ringing in the background. Anyway, I do apologize. But let's get the question started while that is ringing. Because we have a lot to get through because this is a very sort of, it's complex, but it's a very heavy area and it can be very personal for people. So can you just give us the basics? What is the law concerning renting in Ontario?
The law is called the Residential Tenancies Act, and it defines the rights and responsibilities of landlords and tenants in the province.
Great. And see, now everything is a disaster, of course. Just everything's going around. Okay. And what type of rentals are protected by the Residential Tenancies Act and which ones are not?
Most rental units in Ontario are protected by the Residential Tenancies Act, the RTA. The most common type of property that is exempt from the law is when a landlord or a specific member of their family and the tenants share a bathroom or kitchen. Another common type of exempt unit is short-term living accommodations like shelters, seasonal temporary periods in a hotel or a resort, and there are a number of other exemptions. So it's always best to get legal advice to determine if your unit is exempt from the law or not.
Yeah, that's really interesting because we've been getting a lot of questions about Airbnb. So you are hitting the right spot there with that answer. So, what are the rules that apply when someone is applying to rent a place? Why can a landlord refuse someone?
The laws about human rights in Ontario say that landlords must not discriminate against a tenant. Discrimination can happen when a landlord refuses to rent to a tenant because of race, sex, age, sexual orientation, gender identity, gender expression, marital status, color, nationality, religion, the country where you were born, or because you have a disability, you're receiving social assistance, or you have children living with you. There are also other types of discrimination that I didn't note in this list here. In Ontario, landlords are allowed to request income information, past rental history, and can get a tenant's consent to conduct a credit check or a credit reference. And landlords can also ask for a guarantor. Sometimes it can be difficult to know the reason why a tenant was refused by a landlord, because discrimination can be direct
Right.
in the sense like a landlord refusing to rent to you because you have children, or less direct, like if a landlord refuses to set up a ramp for a tenant who has a physical impairment. So it always comes down to the facts.
Right. And then what is a standard form of lease and when does it have to be used?
A residential tenancy agreement, also known as the standard form lease, is a government form that most landlords for private residential rental units must use when entering into a tenancy with a tenant. As of March 1st, 2021, the updated standard lease must be used by most landlords for private residential units. When
Mm-hmm.
completed, the form creates a contract between the landlord and the tenant. However, the standard form lease does not apply to care homes or sites in mobile home parks and land lease communities. Doesn't apply to most social and supportive housing, co-op units, and other types of tenancies that would be exempt under the law.
Right. And then what are the rules around deposits?
Your landlord can ask you to pay a last month's rent deposit before you move in. This deposit can only be used to pay for the last rent before you move out and not for any other purpose. Your landlord can also ask for a deposit for your keys, but it must be given back to you when you move out and return the keys. The key deposit has to be proportionate to the cost that it would actually cost to cover the replacement of those keys.
Right. And then what are the rules about when a landlord can enter your unit? I get a lot of questions about this.
The law says your landlord can enter your home, but there are rules they need to follow. A landlord has the right to come in for certain reasons, as long as they give you notice in writing 24 hours before they plan on entering your unit, and the time of entry has to be between 8 a.m. and 8 p.m. A landlord can come in to do repairs or inspect your unit to see if any repairs are needed, to show your unit to a potential buyer, insurer, or mortgage lender, or to let a real estate agent show your unit to a potential buyer, to have a property inspection done before turning your unit into, or the building into, a condominium, or to come in for any other reasonable purpose that would be listed in your agreement. Your landlord, however, can come into your unit without giving you 24 hours notice if there is an emergency. Your rental agreement says that your landlord gives you cleaning services, or you live in a care home, and your rental agreement says that your landlord has to check on your condition. They can come in at any other time or for any other reason if you give them permission to do so. If you are moving out, if your landlord has given you legal notice to move out, or if you and your landlord agreed that you would move out, your landlord does not have to give you 24 hours written notice, but they have to tell you ahead of time if they are coming, and it must be between those same hours, 8 a.m. to 8 p.m.
Right. So then what are the rules around the supply of heat, water, hot water, and electricity?
Heat, water, hot water, and electricity are referred to as vital services. The law says that your landlord is not allowed to withhold or deliberately interfere with the reasonable supply of those vital services. In Ottawa, we have a heat bylaw number 2010-210, which defines adequate and suitable heat as not less than 16.67 degrees Celsius at night and not less than 20 degrees Celsius during the daytime.
Okay, so next question. Thank you so much, Sarah, by the way, for putting these so wonderfully in one document. And then what are the rules around repair and maintenance, ordinary wear and tear, cleanliness, that type of thing?
Your landlord is responsible for repairing and maintaining your unit. They have to fix or replace anything that is in bad condition, that doesn't work properly. That applies even if, as a tenant, you were aware of the problem before you agreed to move in, or when you agreed to move in, or if your rental agreement says otherwise. As a tenant, you are responsible for willful or negligent damage, while your landlord is responsible for ordinary wear and tear. As a tenant, you're also responsible for the ordinary cleanliness of your unit. When something is replaced by your landlord, however, they don't have to supply you with a new or better model.
So does that include the pile of laundry that I haven't folded?
I wish it did.
Oh, hold on. Okay. All right. Sorry, I kind of lost my list of questions here. Just give me 1 second. And now that I'm thinking about this this pile of laundry here.
I think we're going to talk about what rights tenants have against harassment, threats, or interference. And so on that topic, a landlord cannot substantially interfere with the reasonable enjoyment of a tenant's unit or the residential complex, and a landlord cannot harass, obstruct, coerce, threaten, or interfere with a tenant.
Right.
If a landlord breaches those obligations, then the tenant can file an application at the Landlord and Tenant Board. Oftentimes, the appropriate application to file is a T2 application titled Application About Tenant Rights.
Yeah, and how about then, does that extend to pets, guests, roommates?
A landlord cannot stop you from having a pet in your unit. even if your rental agreement includes such a clause, it would be considered invalid. However, just like almost everything else in the legal world, there are exceptions to that. For example, condominium bylaws can include terms that prohibit pets. A landlord cannot stop a tenant from having guests, roommates, or occupants. A roommate or an occupant is a person who has not signed the lease, but who lives in the rental unit with the permission of the tenant. And typically, a landlord cannot raise the rent or charge extra fees for having additional people living in the unit. That being said, again, there are exceptions, like for rent geared to income housing, because in that case, the tenant is required to inform their housing provider if an additional person will be residing with them past the allowable time provided for in their policies.
And then how can a tenant enforce these rights? Like, are there time limits on them?
If a tenant believes that a landlord breached their rights under the law, the first step is to inform their landlord in writing. In some circumstances, they may also be able to call bylaw to conduct an inspection. In Ottawa, as I'm sure you all know, the number is 311. If those two steps don't resolve the issues, the tenant would then have to bring an application to the landlord and tenant board. Most applications need to be filed within a year of the alleged breach or issue. If the breach or issue hasn't resolved, the time limit, which we also call a limitation period, continues to run up until when the issue is resolved, like in the context of repairs, for example.
Right. And then so I get this question a lot. How often can landlords increase rent?
In most cases, the rent for a unit can be increased if at least 12 months have passed since the last rent increase or since the date the tenancy began. The landlord is required to give a tenant written notice in the proper form at least 90 days before the increase takes effect.
Wow. Okay. And then how much can they increase the rent year by year?
The rent increase percentage is set by the province each year, and for 2024, the rent increase guideline is 2.5%. That is the maximum allowable amount a landlord can increase their tenant's rent without needing the landlord and tenant board's approval. 2.5% is the maximum amount allowed under the law, actually, and in 2023, the amount was also 2.5%, but in 2022, it was 1.2%.
Interesting. And our favorite legal term, are there any exceptions to this rule?
The guideline amount does not apply to new buildings, additions to existing buildings, and most new basement apartments that are occupied for the first time for residential purposes after November 15, 2018. It also does not apply to community or social housing units because those types of units have different rules regarding rent control and rent increases.
Now, a lot of people will want this to actually manifest, but can they actually reduce your rent at some point? Wouldn't that be great?
Yes. So landlords have to decrease the rent when a landlord's property taxes are reduced by more than a certain percentage from one year to the next. This is what's called an automatic rent reduction. Some units are exempt again, like public housing, nonprofit housing. Landlords could also be required to reduce the rent if they are ordered to do so by the landlord and tenant board following a hearing.
Okay. All right. And let's kind of go on to some of the more dicey stuff. So, can a landlord end a tenancy? I get a lot of questions about this too.
Most times when a landlord wants to evict a tenant, they have to give them proper notice, and it has to be for a reason noted in the law. The notice is a written document that would outline the termination date, which is the date the landlord wishes to end the tenancy, the reason why the landlord wishes to end the tenancy, and some other important details like the landlord and the tenant's contact information, the landlord's signature, the date when they signed the notice as well. The notice is just that, a notice. Tenants do not have to move out if they receive a notice from their landlord. Only the landlord and tenant board can evict tenants, and evictions have to be enforced by the Court Enforcement Office of the Superior Court of Justice, which is often referred to as the Sheriff's Office.
Right. And what could tenants be evicted for?
There are what we call at-fault evictions that relate to a tenant's action or inaction, or no-fault evictions that have nothing to do with a tenant's behavior. At-fault evictions or for-cause evictions could include not paying the rent in full, causing damage to the rental property, disturbing other tenants or the landlords, or doing illegal activities in the rental unit or residential complex. Some examples of no-fault evictions include the landlord planning to do major repairs or renovation that require a building permit, and the work can't be done unless the rental unit is empty. The landlord requires the rental unit because the landlord or a member of the landlord's immediate family or their caregiver wishes to move in. The landlord has agreed to sell the property and the purchaser requires all or part of the property because the purchaser, a member of the purchaser's immediate family or their caregiver wishes to move into the unit. In this case, the complex cannot contain more than 3 residential units, and the landlords have to have entered into an agreement of purchase and sale of the complex. And most times, the landlord is required to give compensation to the tenant in these circumstances.
And then what does that eviction process look like?
After a landlord gives a tenant a notice, they would have to bring an application to the landlord and tenant board. Most applications need to be filed within 30 days of the termination date. And most times, once a landlord files an application, the landlord and tenant board would provide both parties with a hearing date. At the hearing, the landlord will present their case, and then the tenant would have an opportunity to present their own arguments. Then the landlord and tenant board will make a decision on whether they are ordering an eviction or not. Since the pandemic, the landlord and tenant board is holding almost all hearings virtually by Zoom.
Oh, interesting. Okay. Just like we're doing now. So there could be cell phones going off in the background there. So what happens after a tenancy term ends? So you have a 1-year tenancy. What happens at the end?
Yeah. Tenants have what we call security of tenancy. And this means that they can continue to occupy a rental unit even after a fixed term tenancy ends, unless they give proper notice that they intend to move out, or both landlord and tenant agree to end the tenancy, or the landlord gives a notice as per the law and the tenant agrees to move out, or they don't agree to move out, but the landlord and tenant board issues an eviction order following the landlord filing an application. If a tenant doesn't give proper notice as required by the law, their fixed term tenancy, like the 12 months, will automatically convert to a monthly tenancy or sometimes weekly or daily tenancy, depending on how the tenant pays the rent. If you paid your rent every month in the expired tenancy agreement, your tenancy will turn into a monthly tenancy, and the original terms of the agreement will continue to apply in that case.
And then what are the rules about subletting? What is a lease assignment and how is it different from subletting?
Subletting refers to when a tenant transfers their entire rental unit to another person, referred to as the subtenant, for a specific period of time, and then the tenant later returns to their unit and the subtenant moves out. In that case, the original lease agreement between the tenant and the landlord remains in place, which means that the head tenant remains responsible for paying rent. The law requires a tenant to get their landlord's permission to sublet their unit, but the landlord is not allowed to arbitrarily or unreasonably stop a tenant from subletting their unit. And if that's the case, the tenant can apply to the landlord and tenant board to determine if their landlord arbitrarily or unreasonably refused to allow them to sublet their unit. Again, there are exceptions, like for rent geared to income units. An assignment is different from subletting because in that case, the original tenant assigns their lease to another person and the agreement becomes with the assignee and the landlord. The original tenant does not return to the rental unit after a period of time as opposed to sublets. So once the assignee's leases begins, the original tenant has no remaining rights to the unit.
Right.
The original tenant still requires their landlord's permission to assign, and if the landlord refuses to allow a tenant to assign their lease, they can give their landlord a specific notice or form named an N9 form to end their tenancy, and the tenant must provide this notice to their landlord within 30 days of the landlord's refusal, and they must provide the landlord with at least 30 days notice before they intend to move out. But first, the tenant has to first allow the landlord 7 days to respond to their request to assign their lease. Just like for sublets, a landlord cannot arbitrarily or unreasonably refuse an assignee.
Right.
And a tenant can bring an application to the landlord and tenant board to make that determination if it gets to that point.
And then how can a tenant end a tenancy after the term?
If you have a fixed term tenancy, again, like a 1-year lease, then you must give at least 60 days notice before the end of the lease, but the termination date cannot be before the last day of the fixed term. If you pay your rent monthly, for example, and you are not in a fixed term tenancy, then you must give at least 60 days notice, and the termination date has to be, again, the last day of a rental month. If you pay your rent daily or weekly, which is less common, and you are not in a fixed term tenancy, then you must give at least 28 days notice, and the termination date, again, has to be the last day of a rental week.
And then what protections are there for renters who aren't covered by the RTA? Obviously, not everyone has this standard kind of arrangement.
Right. Renters who aren't protected by the Residential Tenancies Act could be covered by other types of legislation or could have a potential recourse in civil courts. So it's always best to get legal advice right away in those circumstances.
Cool. And then are these the same rules then for subsidized housing, social housing?
Some sections of the Residential Tenancies Act applies to social or subsidized housing, but the Landlord and Tenant Board does not have jurisdiction to hear, or in other words, does not have the power to make decisions regarding a tenant's loss of subsidy. The Housing Services Act is the law responsible for subsidized housing in Ontario. Aside from the law and the respective regulations, each municipality has their own set of policies created by what we call service managers. Service managers are responsible for overseeing affordable housing projects in their designated areas. In Ottawa, the policies are set by the service manager, which is actually the city of Ottawa.
Mm-hmm. Mm-hmm. And everybody knows I love co-ops. I live in a co-op. So are the rules similar for co-ops?
Most of the Residential Tenancies Act does not apply to co-ops. However, if a co-op wants to evict one of their members, they have to apply to the Landlord and Tenant Board to end a member's tenancy, but they must first terminate the member's membership and occupancy rights and give notice to the member to end their occupancy. Co-op members cannot file applications with the Landlord and Tenant Board themselves. They would have to bring their own concerns to the co-op's board of directors and follow each individual internal processes.
Right. Well, when all is said and done, where can tenants go for more information or to get some help?
Yeah, there are some online resources like stepstojustice.ca for online legal information for tenants. It's a resource providing both legal information and what we call guided pathways to help tenants fill out certain applications. 311, the number for property standards, this could be issues relating to repairs, maintenance, noise, and there's also Community Legal Services of Ottawa. So like I noted, we've got 3 offices across the city, and this is for tenant advice and legal services, and we've got a focus on evictions here at our offices. There is La Clinique Juridique Francophone d'Ottawa for Francophone tenants and to give advice and legal services again. There's the University of Ottawa Community Legal Clinic, again, tenant advice, legal services with a tenant's rights focus. Action Logement is an organization that they assist residents in Ottawa living in the East End. They've got a social housing focus. Mm-hmm. Housing Help, same thing, but for tenants residing in the west of the city. And then there is also the Rental Housing Enforcement Unit. It is a government office, and they can assist tenants with illegal lockouts, cut to vital services, serious issues where a landlord needs to get a call basically from their organization. And if a tenant has a dispute with their landlord related to the offenses in the act, they can work with the Rental Housing Enforcement Unit to solve the problem.
Cool. Okay, so we'll make sure that we put all these links in the description below. And as I indicated, we also have a French version of this exact webinar. It's also on the YouTube page. So that way, if you need this information in French or in English, please watch it over and over and over again. That's how I watch YouTube videos. But, at the end of the day, if you really, really need help, please reach out to my office. Again, this type of legislation isn't necessarily always covered by the municipalities. It's covered by the province, but I will do my best to make sure you can get the help you need or to redirect you in a certain way. So thank you so much, Christelle. We
Thank
really
you.
appreciate it. Thank you, Sarah Ann, for assisting. And hopefully this gives people the information they need to empower them with the rights that they have. So thank you so much, and
very much.
we'll chat soon.
Yes, thank you.